Hey everyone and welcome. I'm your host, bringing you this explainer on behalf of the Real Estate Institute of Rhode Island. Look, I know what you might be thinking. A legal deep dive? But stick with me, because I promise you this is absolutely essential for anyone buying or selling property in the Ocean State. Today, we are taking a close look at Rhode Island General Law Chapter 5-20.8. We're going to completely demystify Rhode Island real estate sales disclosures so you can navigate your very next transaction with absolute confidence. Let's get into it.
To start us off, I want you to think about a seller's disclosure form, kind of like a property's medical history. Providing a medical history doesn't necessarily mean the patient is dying, right? It just outlines any pre-existing conditions, so the doctor, or in our case, the buyer, knows exactly what they're walking into. The entire point of this legal document is just to lay out the known facts, making sure everyone is fully informed before the keys ever change hands.
So here is our game plan for today. 1. The rule of disclosure. 2. Identifying deficient conditions. 3. The 10-day inspection shield. 4. The psychological impact exemption. And finally, 5. Navigating legal exemptions.
Okay, Section 1. The rule of disclosure, the seller's mandate.
Rhode Island law is actually incredibly clear on the seller's mandate here. As soon as practicable, but absolutely before signing any agreement to transfer real estate, the seller has to hand over a formal, written disclosure stating all known deficient conditions. So what exactly is a deficient condition? Well, the law literally defines it as any land restriction, defect, malfunction, breakage, or unsound condition existing on, in, across, or under the real estate of which the seller has knowledge. Now, I really want to emphasize that last part, of which the seller has knowledge. This document is strictly about what the seller actually knows right at the time they fill out the form. The law explicitly states there is no affirmative duty for the seller to go out and hire professionals to conduct brand new inspections just for the sake of the form. It's really just about honesty regarding what you currently know.
Moving right along to Section 2, Identifying Deficient Conditions, the property's physical reality. When we get down to the physical reality of a property, the Rhode Island disclosure form has a pretty massive checklist. Sellers have to check off the condition of everything from the basement and sump pump to the roof, plumbing, and electrical service. But more specifically, the state takes certain environmental and health hazards incredibly seriously. You have to disclose testing and mitigation for radon because radon is definitely a known issue in Rhode Island. If the home was built before 1978, lead paint exposure is a major mandatory disclosure. Sellers also have to provide detailed info about private well water testing, asbestos, and, this is a big one, cesspools. Thanks to the Rhode Island Cesspool Phase-Out Act, determining if there's an old substandard cesspool is a major red flag that absolutely must be documented. No skipping that one. All right, Section 3, the 10-day inspection shield, empowering the buyer. Okay, we've established that sellers have a strict mandate to disclose, but what if they genuinely don't know about a hidden defect? Buyers aren't just left to cross their fingers and hope for the best. The law actually empowers them with a built-in legal defense mechanism. I really want you to burn this number into your memory, 10. Rhode Island law dictates that every single contract for the purchase and sale of real estate must provide potential purchasers with a 10-day period to run inspections. And here is a totally crucial detail. That is 10 days excluding Saturdays, Sundays, and holidays. So we're talking business days here. This 10-day window acts as an impenetrable shield, letting the buyer thoroughly inspect the property before they become legally obligated to buy it.
Which naturally leads us to an obvious question. What exactly can you test for in those 10 days? Well, technically, you can inspect the entire structural integrity of the home, but Rhode Island law specifically guarantees your right to test for a few highly critical hazards. During this 10-day shield, buyers have the legal right to conduct a risk assessment for lead exposure on any pre-1978 builds. They have the absolute right to test private well water for contaminants to ensure it's safe. And they have the right to inspect on-site sewage systems to find out if there's a cesspool down there that's subject to the state's phase-out rules. Now, just a quick aside, the law does specify that the prospective buyer generally foots the bill for collecting and analyzing things like water samples. But honestly, that cost is a super small price to pay to protect what is likely the biggest investment of your life, right?
That brings us to Section 4, the psychological impact exemption. What isn't disclosed? So we've talked extensively about physical defects and environmental hazards, but now I want to introduce a pretty surprising twist. There is a whole category of information that sellers are legally protected from having to disclose, and there is a very distinct dividing line in the law here. On one side, we have the tangible, physical reality of the property. Leaky basements, broken sump pumps, lead paint. Those absolutely must be disclosed if known. On the other side, we have intangible, psychological impacts. The law states explicitly that facts or even suspicions that a property is psychologically impacted are not material facts that require disclosure. This means if the property is suspected of being the site of a homicide, a felony, or a suicide, there is no legal duty to bring it up.
Let's actually read this exact phrasing directly from the general disclaimer on the disclosure form. It says, neither the seller nor listing licensee has a legal duty to disclose issues of psychological impact, including but not limited to homicides, felonies, and suicides on or near the property. Wow. And the law actually goes further, protecting sellers from having to disclose if a previous occupant had a disease that's highly unlikely to be transmitted through occupying the dwelling, specifically mentioning HIV and AIDS. So if you're a buyer and you care about the property's dark history, crime rates, or neighborhood demographics, the burden is 100% on you to investigate that yourself.
And finally, Section 5, navigating legal exemptions. When do the rules change?
While the disclosure rules we've discussed are definitely strict, the state recognizes that in certain transfers, filling out a massive form about a property's condition just isn't practical or legally appropriate. A breakdown derived from the Rhode Island Realtor's disclosure checklist perfectly illustrates these exceptions. In a standard sale, yes, a sales disclosure is absolutely required. However, if a property is being transferred by the executor or administrator of an estate, or maybe by a fiduciary managing a trust, a sales disclosure is actually not required. Why? Well, an executor or a trustee often hasn't lived in the property, so they simply wouldn't have that actual knowledge we talked about earlier to fill out the form honestly. But listen to this, even if you are completely exempt from the standard sales disclosure, the federal lead disclosure is still absolutely required for pre-1978 properties across the board.
There are a few other key scenarios where the law waives the sales disclosure requirement too. We're talking about a transfer to a mortgagee in a foreclosure situation, transfers between co-owners or spouses, like in a divorce settlement, transfers from any governmental entity, the sale of a brand new unoccupied dwelling straight from a builder, or a transfer of title where absolutely no money changes hands, which legally is known as no consideration.
So what does this all mean? The crucial point is this. Knowledge is power in real estate. Sellers, unless you happen to fall into a very specific exemption, you have a legal mandate to honestly disclose what you know about your property's physical condition. And buyers, you are completely empowered with a 10-business-day shield to inspect, test, and verify those conditions, all while bearing in mind that a home's psychological history isn't just going to be handed to you on a silver platter. I'll leave you with this question to ponder. Is your next Rhode Island real estate transaction fully disclosed? Thank you so much for joining me for this explainer, and happy house hunting.